Why? Why did he destroy our lives? There's not one day that we don't suffer for him.
If he had simply stolen Mrs. Klosik's purse for the $20 and not beaten and stomped and choked her to death.
I want to get her. You just don't know how I want to get you. You don't know how I want to get you.
In June 2015, Jaden Chavez Silver was shot and killed during a drive-by while attending a house party in Albuquerque. The fatal shooting sparked outrage and sorrow throughout the community. Just 6 months later, in December 2015, another tragedy unfolded when 18-year-old Arudo Villas was shot during an argument over a beer pong game in South Valley. The shooter in both cases, Kemia Madrid, was eventually linked to Chavez Silver's death after another suspect took a plea deal and provided key information in August 2016. Madrid was subsequently charged with both murders. Madrid later accepted a plea deal for the killing of Arudo Villas and was sentenced to 16 years in prison. During the emotional hearing, Villas's family described their deep loss and disappointment with what they felt was an inadequate punishment.
I hope this man understands the great pain he had caused to me and my family and pays the rightful consequences for all he has done. Why? Why did he destroy our lives? There's not one day that we don't suffer for him.
Madrid showed no remorse during the hearing.
Rotten hell!
Then, in November 2017, Madrid was convicted of first-degree murder in the Chavez Silver case and received a life sentence, equating to 30 years behind bars, to be served consecutively with his earlier 16-year sentence. Though he briefly spoke in court, he denied responsibility, and his attempt to reduce the sentence was rejected. Madrid is expected to remain incarcerated well into his late 50s or 60s. In November 2017, tragedy struck on Detroit's west side when 69-year-old James Haller Jr., a retired Marine and Vietnam veteran, was fatally shot while working part-time at an O'Reilly auto parts store. That afternoon, two women, Shanta Anderson and Ebony McEwen Ross, entered the store with the intent to rob it. During the robbery, Haller walked in from the back of the store and was shot by Anderson. He died in the hospital a few hours later. The crime stunned the community. Haller had returned to work in retirement simply to share his expertise in auto repair and support his family. Within days, police arrested Anderson and McEwen Ross, along with Leviticus Butler, the getaway driver and boyfriend to both women. While Butler cooperated with investigators and received probation, Anderson and McEwen Ross ultimately pleaded guilty to second-degree murder. In June 2018, during the sentencing, Haller's widow, Patricia, gave a powerful statement expressing the depth of her family's pain.
You don't know what you did, young lady. Do you understand me? You don't know what you did. And I wish I could get to you to hang you in here today. I want to get her. Yes, I do, Your Honor. I want to get her. You just don't know how I want to get you. You don't know how I want to get you. Ma'am?
Anderson showed no remorse, calling her actions a mistake, while McEwen Ross offered a tearful apology.
I want to say that people make mistakes, and your mistakes don't define who you are as a person.
And if at all in my power, I'm going to make sure you spend every single year of that sentence to the maximum behind bars. And that's my goal.
I just wanted to get her, but vengeance belongs to God, not me. But at that moment, I just wanted to get her. And I know that wouldn't have been right.
The courtroom was filled with emotion as Haller's loved ones mourned the loss of a man they called a hero, a father, and the heart of their family. Anderson was sentenced to 30 to 60 years in prison, while McEwen Ross received 21 to 50 years. In October 2015, Steve Garrick, a local bartender in Albuquerque, was shot and killed while trying to protect his wife during a break-in at their home near Indian School and Tramway.
He was at the wrong time, but the right place. He was at his home, and he was protecting my mother. And if he hadn't done that, my mom would be dead too.
A group of 6 boys, Ryan Archiebeck, Andrew Hubler, Jeremiah King, Christopher Rodriguez, Matthew Baldonado, and Enrique Palomino, had reportedly broken into the house when Garrett confronted them in his driveway. His courageous act cost him his life, and the case sent shockwaves through the community. Following the incident, all 6 boys were charged in connection with Garrett's death. In 2016, Andrew Hubler avoided a murder trial by pleading guilty to lesser felonies and later posting bond, prompting outrage from Garrett's family, who said they were never notified.
If they're gonna let people that are accused of murder be on the street, then part of the victim's advocate realm should have notified our family to let us know that, you know, we could sleep a little less tonight. I feel like I've been punished and sentenced to a system that is broken. That's a slap in the face to my dad. My dad doesn't get to be home for Thanksgiving. He doesn't get to have Christmas.
In 2017, Ryan Archiebeck also accepted a plea deal, admitting guilt to multiple felonies, but was sentenced under juvenile guidelines. He received supervised probation until age 21, along with mandatory rehabilitation and 800 hours of community service. Jeremiah King, considered one of the more involved suspects, was tried as an adult and sentenced to 25 years in prison. On May 27, 2017, 18-year-old Chaylin Funes was involved in a deadly incident in Visalia, California. During a Memorial Day weekend gathering, Eric Fisher, a devoted husband and father, attempted to break up an argument involving Funes' boyfriend and another man. Witnesses reported that after Fisher told them to take the argument elsewhere, Funes deliberately struck him with her car. Funes fled the scene, but was arrested days later following an anonymous tip. Fisher died that night from his injuries. Nearly a year later, a Tulare County jury convicted Funes of second-degree murder with a special allegation, as well as hit and run causing death. At sentencing, her attorney pleaded for leniency, arguing she was young, inexperienced, and acted out of panic.
She has remorse. She knows that through me as her attorney, this is her last plea for this court to consider and give her a real chance of proving that she can lead a productive life.
She could have stopped the car and she could have helped him after the first hit, after the second hit, after dragging his body, after his body was dislodged, after the turn on Turner Street.
Funes addressed the court, expressing shame and claiming she never intended to kill Fisher.
I tore your family apart and I caused awful pain to Mr. Fisher. I'm sorry, I'm ashamed, and I'm willing to face my consequences.
The moment she decided to take his life became the same moment she robbed me and my children of a lifetime of love, memories, and a future.
Judge Joseph Kalashian rejected the plea, calling her apology insincere and her tears crocodile tears. Acknowledging the irreversible pain caused to Fisher's family, the judge sentenced her to 16 years to life in prison. In June 2024, 53-year-old Marcus Genovese of Angola, New York, was driving a pickup truck on Lakeshore Road in Hamburg while under the influence of alcohol, hydrocodone, and traces of cocaine. Without a valid license, Genovese rear-ended a stopped SUV that was waiting to make a turn. In the back seat of the SUV were 2 boys, Thomas Ross and his brother Anthony. The crash severely injured both, but while Anthony survived, Thomas died from his injuries. Genovese fled the scene on foot and was later located by authorities hiding in nearby woods. Following the crash, Genovese was indicted on multiple charges, including second-degree manslaughter, vehicular manslaughter, and fleeing the scene of a fatal accident. In March 2025, he pleaded guilty to the most serious of those charges. During the emotional sentencing in May, Thomas's family delivered heartbreaking impact statements describing the lasting trauma of their loss.
You, Marcus, took us from a family of 4 to a family of 3. And every day since, for 348 days, the accident has been replaying in my mind over and over and over. You ran. While I wrapped a sweater around Thomas's head in an attempt to stop the bleeding, you ran. While I screamed and begged for help, you ran. I know you heard me. How different things may have been had you took accountability for your actions and in the least called 911 for help.
His mother recalled the moment she tried to save her son while Genovese ran away, and how Anthony, now grieving, sleeps beside his brother's cremation box.
Anthony, who has learned too early that life is not fair, who looks for signs of love from his brother in every chance that he can, that understands the invisible string theory better than any kid should, that the only way that he can have a sleepover with his brother is by laying next to his cremation box.
He was sunshine. He was laughter that filled a room. He was the kind of child who could find something magical in the smallest moments. His hugs were real, his questions were endless, and his dreams were already so big.
Genovese apologized in court, expressing remorse for his actions.
There's nothing in the world I can say to make up for this. Just extremely, deeply sorry.
You remained a coward and a disgrace of a human being.
Erie County Court Judge James Bargnesi sentenced him to 5 to 15 years in prison and permanently revoked his driver's license. The sentencing brought some accountability, but can never replace the light lost with Thomas's passing. In March 2022, a heartbreaking incident unfolded on Detroit's east side when 20-year-old Sierra Wells was fatally shot in a case of mistaken identity. She was driving to the market with her mother and sister just one day after her birthday when Marion Johnson, 19, opened fire from outside his home on Madeline Street. Mistaking their vehicle for one allegedly involved in an earlier altercation, Johnson fired a high-powered weapon, striking Sierra. She was later pronounced dead at the hospital.
And then that's when Sierra said, "Mom, I'm shot." She has so much to live for. Her whole life ahead of her.
Within hours, police used ShotSpotter technology to trace the shots to Johnson's location. He was arrested and charged with first-degree murder, assault with intent to murder, and multiple firearm offenses.
That could have been anyone. An incident that occurred prior in the day involving a vehicle similar, nothing to do with our victims, and our offender, for whatever reason, decided to get retribution for that incident with the use of a high-powered rifle.
In court, his attorney claimed Johnson believed he was defending himself from a group of young men he thought were approaching to attack him.
What rationale and reasoning does that give for the allegations for Mr. Johnson to fire numerous shots into an occupied vehicle with 3 young women?
The judge, unconvinced by the defense, denied bond and remanded Johnson to jail. Sierra's family, devastated by the loss, described her as a hard-working young woman taking online college courses while working at FedEx. As of now, Johnson remains in custody awaiting trial, with no sentencing yet issued. On March 2, 1999, 84-year-old Helen Klochek was brutally attacked after leaving a restaurant in Plymouth Township, Michigan. Her purse, which contained just $20, was stolen, and her body was later found in an alley behind a church on Detroit's west side. The elderly woman had been physically assaulted. Despite intensive efforts, the case went cold for years, with no immediate leads on who committed the crime. It wasn't until 2008 that a breakthrough emerged. A Kevlar glove left in the back seat of Helen's abandoned and torched car was re-examined with advanced DNA technology. In 2011, the DNA matched that of Nosakare Onomonu, a convicted felon already serving time for unrelated crimes.
If he had simply stolen Mrs. Klosek's purse for the $20 or so she probably had in it, and not beaten and stomped and choked her to death, a tiny, helpless woman, he almost certainly would have gotten away with the money, avoided being prosecuted.
He was charged with Klochek's murder while awaiting release from prison. During sentencing, Helen's daughter addressed the court.
On March 2nd, 1999, you chose to take the life of another human being. Her name was Helen Klosek. She was our mother, a grandmother, great-grandmother, and a friend. She was 84.5 years of age, stood 4 foot 5 inches tall, and had a bad knee. We should have been able to hear her laughter, enjoy her sense of humor, and her joy at seeing the grandchildren and great-grandchildren. She loved being with family during birthdays, holidays, summer outings, a weekday dinner, going to the mall, and all the other family doings. Instead, all we can do is feel pain in our hearts and minds for what you did to her.
In 2015, more than 16 years after the killing, Anamonu was convicted and sentenced to life in prison without the possibility of parole. Helen's family finally received a measure of justice, though the pain of her loss, they said, could never be erased. Despite the conviction, Anamonu continued to claim he was framed and vowed to appeal. On a summer evening, 20-year-old Robert Mooney made a tragic decision that would change multiple lives forever. After a night of drinking, Mooney got behind the wheel with his best friend, Joseph Cavallari, in the passenger seat. What began as an ordinary night ended in disaster when Mooney, driving under the influence, lost control of the car. The crash proved fatal, claiming the life of Cavallari, a young father and beloved son. Mooney's blood alcohol level was nearly twice the legal limit, and he was later arrested and charged with DUI and vehicular manslaughter. At sentencing, the courtroom was filled to capacity with family and friends, many of whom were turned away due to limited space.
What was taken from me will never come back. He told people he couldn't bring himself to apologize to me. It was something he just couldn't do. Well, I'm sorry, but I can't live without my son, but I'm being forced to.
So he can't even look them in the eye right now, because he doesn't know what to say. He knows he's let them down.
Cavallari's mother tearfully described the pain of losing her son and expressed how much it hurt that Mooney had not apologized. At last, Mooney broke his silence, addressing the family with deep remorse.
We thought of each other as brothers, and I couldn't ask for a better friend to have. I can't express how much I am so sorry for the thing that I've done and the bad decision I've made to take away a son, a father, a brother, and I can't imagine the pain that you go through.
Judge Kenneth Case himself grew emotional, even choking up as he read a heartfelt letter from Mooney's friends.
I understand he would never have wanted this to happen. Robert's a kind person and a friend to many. This incident was an eye-opener to many. I believe Robert has learned a valuable lesson, and living with this tragedy is a task in itself.
Judge Kenneth Case delivered a sentence of 1 to 3 years in prison, acknowledging that while Mooney's decision to drink and drive was intentional, there was no intent to harm his friend. In August 2021, Delia Johnson, a 42-year-old mother, was shot while standing on a Brooklyn sidewalk following a vigil. The brazen killing, caught on surveillance video, shocked the community. Claudia Banton, a woman Johnson's family once considered part of their own, was identified as the shooter. Authorities launched a multi-month manhunt, eventually locating Banton in Jacksonville, Florida, nearly 4 months after the murder. In April 2025, a jury found Banton guilty of second-degree murder and criminal possession of a weapon. On May 19, 2025, she was sentenced to 23 years to life in prison. During the emotional sentencing, Johnson's mother delivered a powerful victim impact statement, expressing heartbreak over the betrayal. Johnson's daughter, currently serving in the Air Force, joined virtually, struggling through tears to speak.
I feel she deserved more, but today is about changing. Today is about forgiving. And it ain't easy, but I know one day it will get better.
I'm glad that this is over. It felt good because it was a release.
Though Banton remained silent, her lawyer said it wasn't due to indifference.
But it's very difficult for someone to absorb that type of speech from people that you know and love.
The judge, also moved to tears, acknowledged the deep, lasting pain Johnson's family endured. As Banton's attorney prepares to file an appeal, the family says justice has been served, and their path toward healing can now begin. In November 2016, a U.S. Border Patrol agent approached 6 men at a gate gas station in Yulee, Florida, suspecting them of being in the country illegally. Among them was Francisco Portillo Fuentes, a previously deported immigrant from El Salvador. Surveillance footage later revealed inconsistencies in the agent's account, showing that 2 Nassau County deputies, whom he claimed were present during the initial encounter, were not there at the time. When 3 of the men admitted their undocumented status, the situation escalated. Portillo Fuentes fled on foot, triggering a chase. Deputy Eric Oliver of the Nassau County Sheriff's Office ran after him, attempting to cross a highway, where he was fatally struck by an SUV. Portillo Fuentes was captured later that night and charged with multiple offenses, including felony murder and aggravated manslaughter. His defense team argued that the incident was a tragic accident, fueled by misleading testimony and improper pursuit procedures. They claimed Portillo Fuentes had no intent to cause harm and pointed to surveillance video contradicting key parts of the prosecution's case. After lengthy proceedings, he pleaded guilty to aggravated manslaughter and was sentenced to 12 years in prison in 2021. Portillo Fuentes is expected to be deported after serving his sentence. In August 2017, Damon Grimes was riding his ATV through a neighborhood on Detroit's east side when he caught the attention of Michigan State Police troopers. According to police, Damon ignored a stop sign and refused to pull over when officers tried to stop him. Trooper Mark Bessner, riding as a passenger in the patrol car, decided to fire his taser at Damon while the boy was driving the ATV at about 35 to 40 miles per hour. The shock caused Damon to lose control. He crashed into the back of a parked pickup truck, suffering fatal injuries. The medical examiner ruled his death an accident caused by injury. However, Damon's family has always disputed the police version. They believe the patrol car actually struck Damon's ATV from behind and into the truck. They say Bessner then left the scene without offering help. An investigation revealed that Bessner had a history of questionable taser use. Not long after Damon's death, and was charged with second-degree murder and involuntary manslaughter.
Homicide, manslaughter, misdemeanor, count 3, homicide, manslaughter, gross negligence. This matter is scheduled for examination.
Mr. Prosecutor.
Robert Donaldson, appearing on behalf of the people.
Matthew Penny, Your Honor. Good morning.
Good morning, Judge. Rick Convertino on behalf of Mr. Bessner, who's in the courtroom to my left, sir.
Today's date and time set for examination. We've had multiple sidebars at this point.
Yes, sir. Judge, thank you, Your Honor. We're seeking a brief adjournment in this case. The discovery is voluminous. I haven't had a chance to get through all of it. There are 53 or so independent discs that were provided and thousands of pages of discovery. And so I'm seeking a brief adjournment. I've discussed this with Mr. Donaldson and Mr. Penny. Just a week is what we seek, Judge.
Has all the discovery been turned over at this point?
There's one disc that is still outstanding that's available upstairs, and I anticipate Mr. Convertino can pick it up today.
I will.
Your Honor, if I might.
Yes.
Counsel and I, Mr. Penny, have discussed the nature and presentation of proofs. We have worked out a number of stipulations in that regard, and I think that Mr. Convertino should be more than ready in a week, and we're prepared to do that.
To those stipulations, Your Honor, I actually have them printed out. I have them marked as People's Proposed Exhibit Number 8, signed by myself and Mr. Convertino at the bottom. Is that correct?
Yes, sir. Thank you.
And I'd move, I suppose I can move for its admission right now. We can make it a part of the record.
Any objection to the admission of the People's Exhibit 1?
No, sir.
8, Your Honor.
8. Will be admitted.
Thank you.
All right. With that being said, the matter will be adjourned to February 1st, 2018, 9 a.m.
Thank you, Your Honor.
Thank you.
Judge, pardon me, sir. I'd like an opportunity to readdress bond in court. Receive the pre-investigation summary. May I approach, Judge?
Yes, I haven't seen it.
Has the court had an opportunity to review that, Judge?
Yes.
Thank you. As you know, the recommendation is for a reduced amount, which is $500,000, 10% cash surety. But ask that the court consider a further reduction of $100,000, 10% cash surety, and based upon all of the information included in the pre-sentence investigative report, or the pre-trial investigative report, and we'd ask that the court consider that. He's not a risk of flight in any way. He himself served himself up at the appointed time and place. He is not a risk of flight in any manner. He is certainly not a danger to the community. We'd ask the court that it would take into consideration all the factors in the report in front of you and reduce the bond to $100,000, 10% cash assured.
My only position is I think counsel is misapprehending the statute that applies to homicide cases where the proof is evident, the presumption is great. Presumption in that circumstance is a remand. That being said, the people take no position with leave it to the discretion of the court.
At this time, due to the fact there have been no proofs on this record, the only thing we had made in is one stipulation. The court is going to take no action on bond. I will review the pre-sentence report, and I will take it into account. And again, I'll allow another bond argument at the next hearing. But since there is no new proofs, there are no evidence that has been placed on this record, bond continues at $1 million. Okay.
Thank you, Your Honor.
Thank you, Judge.
You're all set.
In early 2018, Bessner waived his preliminary hearing and was released on a $1 million bond while awaiting trial. At the same time, Damon's family filed a $50 million lawsuit accusing Bessner of wrongful death. The first criminal trial ended with a hung jury, but in the second trial, Bessner was found guilty of involuntary manslaughter.
And I note for the record, Mr. Bessner is present, and our 12 jurors have returned to the courtroom. Good afternoon, ladies and gentlemen. You have been diligently deliberating since about 3 o'clock yesterday, and we received one note asking for some clarification, and then we received another note before we could respond saying you've reached a verdict. Is that correct? Yes. And who is your foreperson? Juror number 5. Could you please stand? And the clerk is going to ask you what your verdict is, and after she asks you how you find, I want you to read exactly what is next to the box that you checkmarked.
On the matter of People versus Mark Lynn Bessner, how do you find the defendant?
Guilty of the lesser offense of count 2, involuntary manslaughter.
Will all members of the jury please stand and raise your right hand? You say upon your oath that you find the defendant, Mark Lynn Bessner, guilty of the lesser offense of count 2, involuntary manslaughter. So say you, Mr. Foreperson. Say all members of the jury.
Thank you.
During sentencing in 2019, Wayne County Circuit Judge Margaret Van Houten told Bessner that his actions added to the community's distrust of police and betrayed the public trust that comes with wearing a badge. She noted that Bessner's use of the taser contradicted his training and went beyond what any reasonable officer should do.
To know we will never hear him laugh again. There will be no more hugs and kisses from him. The smile that was let out the room. We will never see him again.
And I want the family to know, the Grimes family to know, I am sorry. I think about it every day. And if there were a time machine I could go, that I could jump into and go back and change that outcome, I would.
The judge handed down a sentence of 5 to 15 years in prison, which was higher than the guidelines recommended, emphasizing Damon's young age and Bessner's responsibility as a trained officer. Before being taken away, Bessner apologized in court, saying he thought about Damon every day and wished he could undo what happened. For Damon's family, however, the loss remains, and their civil case against Bessner and the state police is still ongoing. In January 2012, Jane Bashara, a respected marketing executive from Grosse Pointe Park, Michigan, disappeared after attending a business meeting. The next day, her SUV was found abandoned in Detroit. Inside, Jane had lost her life under suspicious circumstances. Very quickly, suspicion fell on her husband, Bob Bashara, a well-known local businessman who outwardly appeared to be a devoted family man. Behind closed doors, he was involved in an alternative adult lifestyle and was leading secret relationships outside his marriage. Police attention turned to Joe Gentz, a handyman who sometimes worked for Bashara. In a confession to police, Gentz claimed Bashara hired him to Jane, promising him cash, a Cadillac, and other rewards. He said he Jane in the family garage while Bashara watched. In 2014, after more than 2 years of investigation and media coverage, Bashara went to trial. Prosecutors painted him as the mastermind who wanted his wife dead so he could freely pursue his secret lifestyle and control her money. The trial lasted weeks and included testimony from dozens of witnesses, including details of Bashara's affairs and his attempts to hire someone to kill Gents while he was in jail to keep him silent. In December 2014, a jury convicted Bashara of first-degree premeditated murder, conspiracy, solicitation to murder, obstruction of justice, and witness intimidation.
You once said you were living the dream, now you experiencing a nightmare. You created. You destroy your life, and the lives you touch were damaged by your touch. I have no mercy for you. The Bible says to be absent from the body is to be present with Christ. Jane is an angel of light. However, I would like to say to the family of Jane that forgiveness is never about the other person. It's your willingness to no longer be bound by another person's madness. And it's not saying that what you did was okay, but it's saying I am not going to let what you did ruin my happiness forever. As a judge on this side of eternity, today there will be justice for Jane. As to count 1, conspiracy to commit first-degree premeditated murder, the court is going to sentence you.
The sentence is under 750-316 until mandatory life.
To mandatory life. Count 2, the court is going to sentence you to no less than 19, no more than 40. Count 3 is life without parole. Count 4, obstruction of justice, 1 to 5, and witness bribery intimidation, 2 to 10.
Judge, on the sentence for the second count solicitation, that is technically above the guidelines, I believe.
18 to 40.
Thank you, Judge.
Very good. You have 42 days to appeal my decision. Now, for attorney want to be appointed to you, have 42 days to appeal my decision. You will be given 618 days credit. That concludes this matter. Thank you.
Judge Vonda Evans sentenced him to life in prison without parole, describing his actions as cold and calculated, not ready to give up. Bashara later filed a motion for a new trial.
On December 18, 2014, following a jury trial, defendant Robert Bashir was convicted of conspiracy to commit first-degree murder, solicitation of murder, first-degree premeditated murder, obstruction of justice, and witness intimidation. On January 15, 2015, the defendant was sentenced to life without parole after a very long and protracted trial where over 80 witnesses were presented. On July 30, 2015, the defendant filed a motion for a new trial. In the defendant's motion for a new trial, he alleges 6 claims, all of which fall under ineffective assistance of counsel. The claims were failure of the defense counsel to request a change of venue due to the high publicity of the case, faulty jury selection, and denial of the defendant's right to present a defense. Basically, he indicated that it was the failure of the investigators to properly investigate and to assist the defense attorneys. The defense attorneys' failure to file a motion regarding the preservation of Jane Bashira's clothing after she was taken to the morgue, and a violation of the defendant's Sixth Amendment right to confront his accuser, Joe Gentz. The co-conspirator who committed the murder, Joe Gentz's statements were introduced into trial, but he chose to assert the fifth, and it was appellate counsel's belief that this was done in error and that the defendant was denied the right to scrutinize the statements of Joe Gentz to the police. His out-of-court statements implicating the defendant were nothing more than a backdoor way of presenting such evidence to the jury without the scrutiny of cross-examination. And lastly, the court's example of reasonable doubt was inappropriate. Also, the fact that the defendant wanted to take the stand and his attorneys advised against that. When the court has to determine whether or not there's ineffective assistance of counsel, the court has to look at 2 things. Was the attorney's performance so deficient And if so, the deficient performance prejudiced the defendant. In other words, there's a reasonable probability that but for counsel's error, the result of the proceeding would be different. An attorney is presumed to have valid strategy basis for anything that they've done. The defendant has the burden to establish both deficient performance and prejudice. Moreover, according to MCL 770.1, the court can vacate a conviction and order a new trial for any cause or which by law a new trial may be granted, or when it appears to the court that justice has not been served. 76.926 grants the court authority to vacate a conviction where it appears after an examination of the entire case, it affirmatively appears that the errors complained of have resulted in a miscarriage of justice. A new trial also can be based upon the fact that there's newly discovered evidence and the defendant has the burden to establish factually ineffective assistance counsel and the basis of a new trial for the miscarriage of justice.
He claimed his defense lawyers had failed him, accusing them of not changing the trial's location despite heavy media coverage, mishandling jury selection, ignoring evidence like his wife's clothing that could have been tested, and stopping him from fully telling his side of the story. He also argued that statements from Joe Gentz should not have been allowed because Gentz refused to testify in full at trial. In 2016, Judge Evans held a lengthy hearing to examine these claims. Bashara's old lawyers and investigators testified that they had given him every possible resource, skilled attorneys, expert consultants, and investigators, and that Bashara himself approved many decisions during the trial. Bashara even praised his legal team in letters at the time. Joe Gentz's affidavit, which Bashara hoped would help him, did the opposite. When called to testify, Gentz repeated that Bashara planned the murder and paid him to carry it out.
That there was no evidence except your vivid imagination. Instead, the evidence portrayed a man who thought he was smart and calculating that he could have someone murdered in the Wayne County Jail. Your only purpose was to prevent this idiot, as you referred to him, from revealing the truth that you had hired him to kill your wife. You planned, groomed, and masterminded this pitiful plot to murder your wife and dump her body in Detroit like garbage, with a staged crime scene in one of the poorest areas of Detroit, hoping locals who would steal the car and contaminate the crime scene. You would finally be able to be free to live your new life in this seedy, manipulative lifestyle you dreamed of, financed exclusively by Jane's money. But what you did not realize is the person you called an idiot would reveal your manipulative plan to rid yourself of your Jane. He cleverly signed an affidavit which your attorney took the bait, accepted it, and believed that it would set you free. But you never dreamed that this idiot that you claimed would be the one to outmaneuver Master Bob. With that, the court finds that the defense has not carried its burden to find that the attorneys were deficient.
In the end, Judge Evans rejected Bashara's request for a new trial. She ruled that his defense had been thorough, that there was no credible new evidence, and that his claims failed to show any miscarriage of justice. She described Bashara as a manipulator who had tried to rewrite the story but couldn't change the facts. He had orchestrated his wife's murder and dumped her body like trash to chase a selfish double life. Bob Bashara remains in prison, serving life without parole. His final appeals failed, and his case stands as one of Detroit's most chilling examples of a hidden life turned deadly. In May 2010, a tragic police raid changed a Detroit family forever. Ayanna Stanley Jones was sleeping on a living room couch next to her grandmother when a Detroit police SWAT team arrived to search for a murder suspect believed to be inside the same duplex. Officer Joseph Weekly, part of the city's special response team, was assigned to help lead the entry. As officers moved in, they used a distraction device to quickly secure the home. In the tense moments that followed, Officer Weekly's weapon fired. Ayanna, still asleep asleep just moments earlier, was hit and did not survive. The raid quickly drew national attention. Community members and Ayanna's family questioned how a sleeping girl could lose her life during a police operation. Weekly claimed the girl's grandmother had accidentally bumped his weapon, causing it to fire, a claim the family strongly denied. After a lengthy investigation, prosecutors charged Weekly in October 2011 with involuntary manslaughter and reckless endangerment, arguing that he failed to handle his weapon with proper care during a dangerous entry. The first trial in 2013 ended in a mistrial when the jury couldn't reach a decision. A second trial began in 2014. Prosecutors said Weekly's handling of his weapon showed gross negligence, meaning he knew the risks but failed to act with the care required. The defense argued the shooting was a terrible accident, not a crime. During the second trial, the judge reviewed the evidence and the legal definition of gross negligence, which requires a willful disregard for obvious danger.
The instructions on the manslaughter involuntary reads as follows. To prove this charge, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Ayanna Stanley Jones. That is, that Ms. Jones died as a result of. Second, in doing the act that caused Ms. Jones's death, the defendant acted in a grossly negligent manner. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, the trier of fact must find each of the following things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another, when to a reasonable person it must have been apparent that the result was likely to be serious injury. The key word here in this instruction is gross negligence means willfully disregarding the results to others. Now, as I see this instruction, I'm not really clear whether the three elements that the trier of fact would have to find coincide with willfulness. I don't see that. So, and I also don't see that there is evidence in this case that supports, or evidence whether it supports or not support. I don't see the evidence that the defendant willfully disregarded the results to others. The entire trial has basically been about the carelessness of the defendant based on his skills. So, looking at the evidence in the light most favorable to the prosecution, there seems to be a conflict between one part of the instruction and another part of the instruction. There is no evidence in this court's opinion that supports willfully disregarding the results to others. But the three things that the trier of fact has to look at for gross negligence really are questions for a trier of fact. The trier of fact could decide if the defendant knew of the danger to another, that he knew that there was a situation that required him to take ordinary care to avoid injuring another. The trier of fact can decide that whether the defendant could have avoided injuring another by using ordinary care. And the trier of fact can decide if the defendant failed to use the ordinary care to prevent injuring another. when to a reasonable person it must have been apparent that the result was likely to be serious injury. So with this conflict, I'm going to, if I am going to err, I'm going to err on the side of the defense, and I'm going to grant the motion for dismissing count one.
Thank you, Judge.
Okay.
Your Honor, people object to that, and people ask for a stay before we do closing arguments so that I can talk to my supervisors upstairs about an emergency interlocutory appeal, because it's our position that the elements have been satisfied as the court indicated, and the legal definition is willfulness, and the jury has to decide the elements of the crime, and that's what the court instructs them. And the elements, as the court has said, are there. There's enough on this record to send this to the jury on the elements of involuntary manslaughter.
I think that the elements on A, B, and C are there. What is confusing is in the definition of gross negligence, it says that the act must be willful, and I haven't heard. I don't know if I've heard anything about a willfulness to perform the act or failure to perform the act. I've heard carelessness.
We've heard lots of testimony about the standard of ordinary care, what that standard of ordinary care is, the training, the equipment, all of that stuff that we've heard over and over again about what the standard of care is. Right. The definition of gross negligence means willfully disregarding the results to others. It's defining that as being more than just carelessness or recklessness, more than just ordinary negligence. If the court looks at the jury instruction that defines the differences between negligence, it talks about that.
Right, the degree of negligence.
Right, how gross negligence is a higher degree of negligence. It's not an intentional crime. We've never said that the court that this is an intentional crime. Gross negligence is not an intentional crime. It is a crime that occurs when someone knows better and someone knows they're supposed to do something and they don't do it, or they have an act they're supposed to perform, and they don't do that act, or they fail to perform an act they're supposed to perform. And that's how the courts have defined gross negligence as a willful violation. But for the jury, they have to decide the three elements of the crime. They don't decide whether it's willful or not. They decide, is it gross negligence? And the way they do that is A, B, and C. And if they find A, B, and C, that means it's gross negligence. That means it's a willful violation. Because we all know the jury instructions say that you take everything as a whole, but you're also going to look at the elements of the crime. That's all I have to prove. So if the jury decides that I proved A, B, and C, they find gross negligence, that by legal definition is a willful violation of his obligation to act. That's how the courts have defined gross negligence. It's a bad jury instruction, but the elements,
right.
Yes, the elements are clear. The elements are clear, and the court has said that we have satisfied the elements. Okay. And for that reason, it should go to the jury.
The judge found that while there was evidence of mistakes and carelessness, there wasn't enough proof that Weekly had consciously ignored clear risks in a criminal sense. In October 2014, the judge dismissed the involuntary manslaughter charge. Soon after, the jury deadlocked again on the lesser charge of reckless use of a firearm, forcing another mistrial. By early 2015, prosecutors dropped the final charge altogether, ending the criminal case. Ayanna's family expressed deep frustration and heartbreak over the decision, feeling there was no real accountability for her death. In May 2015, Michigan State Senator Virgil Smith Jr. made headlines for all the wrong reasons. After an argument with his ex-wife outside his Detroit home, Smith fired at her parked SUV. While no one was hurt, the car was badly damaged, and police arrested Smith shortly after. Prosecutors charged him with 4 crimes: malicious destruction of property, assault with a dangerous weapon, felony firearm, and domestic violence. Together, these charges carried serious prison time if he was convicted. In February 2016, Smith reached a plea deal to avoid a trial. He agreed to plead guilty to malicious destruction of property, a felony, while the other charges would would be dropped. In exchange, Smith would serve 10 months in jail, spend 5 years on probation, get treatment for alcohol use, undergo a mental health evaluation, and pay restitution for the damage. One unusual condition of the deal required Smith to resign from his Senate seat and promise not to run for or hold any elected or appointed office while on probation.
Count 1, malicious destruction of personal property, the damage or injury being $20,000 or more, a felony with a maximum penalty of 10 years in prison. Count 2, assault with a dangerous weapon, also known as felonious assault, a felony with a maximum penalty of 4 years in prison. Count 3, felony firearm, a felony with a mandatory penalty of 2 years in prison, the 2 years to be served consecutively to and preceding any term of imprisonment imposed for counts 1 and or 2. This crime is sometimes referred to as the one with gets you 2. And count 4, domestic violence, a misdemeanor with a maximum penalty of 93 days in jail. The charges are not related to his official duties. On February 11, 2016, the prosecutor and the defendant presented the court with a signed settlement offer and notice of acceptance, which is attached to this opinion and order as Appendix A. The defendant would plead guilty to count 1, malicious destruction of personal property, with the following sentence agreement: 10 months in the Wayne County Jail with no early release, 5 years probation, resign position as state senator, cannot hold elective or appointed office during full pendency of probation, alcohol and drug treatment, monthly documentation, mental health evaluation, full compliance with treatment, monthly documentation, surrender weapon used, full restitution to be determined by the court. In exchange, the prosecutor would dismiss count 2, felonious assault, count 3, felony firearm, and count 4, domestic violence. The plea and sentence agreement, which I refer to as the plea agreement, was put on the record and the defendant pled guilty. The defendant appeared for sentencing on March 14, 2016. He had not resigned his position as state senator. The court sentenced him to 10 months in jail and 5 years probation, but decided, without being asked by the parties to decide, that the portions of the plea agreement that required the defendant to, quote, resign his position as state senator and not hold the elective or appointed office during full pendency of probation are void. The court stated its reasons for this ruling on the record and in an order declaring void portions of the plea agreement. The defendant has not resigned. The prosecutor filed a motion to vacate plea. Michigan Court Rule 6.310, capital letter E, provides that on the prosecutor's motion, the court may vacate a plea if the defendant has failed to comply with the terms of the agreement. The prosecutor writes, quote, while the people understand the court's reluctance to order defendant to resign from office, defendant is able to comply with the terms of the plea agreement without a directive of the court. Having not done so, the court must vacate the plea.
When Smith came back to court in March 2016 for sentencing, the judge accepted the jail time and probation terms, but refused to enforce the parts of the deal that required Smith to quit politics. The judge ruled that forcing an elected official to resign violated the state constitution and voters' rights. Prosecutors then tried to have the entire plea thrown out, arguing that Smith hadn't lived up to his side of the deal by staying in office. But the judge ruled that removing the political conditions did not break the rest of the agreement, and that the plea could stand as is. Smith began his 10-month jail sentence in March, and officially resigned from the Senate just a few days later. Despite the controversy, he later attempted a political comeback by running for Detroit City Council in 2017, which sparked more legal challenges. In the end, the court said he could run, but voters rejected his bid. In In February 2022, Christian Eppinger, a young Atlanta man prosecutors linked to the YSL gang, was arrested after a violent encounter that grabbed citywide attention. According to police, Eppinger shot an Atlanta police officer, David Rogers, at close range while resisting arrest during a traffic stop. Despite his injuries, Officer Rogers survived. This incident wasn't isolated. Eppinger already had a criminal record and was on probation at the time, a probation that explicitly barred him from possessing any firearms. Prosecutors argued that by ignoring this condition, Eppinger not only broke the law again, but also directly enabled the shooting that nearly killed an officer. When Fulton County brought sweeping RICO charges against the group known as YSL Young Slime Life, Eppinger was named alongside more than 24 others. The state claimed YSL wasn't just a music label, but also operated as a violent street gang, responsible for a series of crimes, including shootings, armed robberies, and assaults, facing overwhelming evidence, including video footage, text messages, and even his own recorded statements. Eppinger chose not to go through a full trial. In June 2025, he entered what's known as an Alford plea. Under this type of plea, the defendant doesn't admit guilt outright, but accepts that prosecutors have enough evidence to convict him.
I found there to be a factual basis for this plea, and I will accept the plea as freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences and the sentence. And let me say a couple of things. Only one overt act, as we all know, needs to be proven to establish RICO. On counts 27 and 29, I believe that the defendant's own words inculpate him in the crimes, and I note that he talked about telling the victim to take off the earrings too, which was a part of what was stolen in the case. That certainly seems to, in the court's estimation, inculpate him in those crimes as an absolute willing participant. 31, understandably, considering what we see on video, the defense has really not argued anything at all. Appreciate that, that y'all acknowledge that at least that is pretty clear. In counts 32 through 39, the video, in addition to State's Exhibit number 1, shows the officer to be in uniform, and I do not think that charging attempted murder is an overcharge, considering that Mr. Eppinger, and we hear 6 shots on the video, pumps 6 shots at close range into a uniformed officer, and then laughs about it afterwards, including saying something to the effect of, yeah, he's telling me to get down, I ain't getting down. I think that considering the prior history, the number of different incidents, honestly almost back to back to back to back, from him getting out on first offender probation and deciding he's not going to change his life, he's not going to take the opportunity he's been given. And many of these incidents wouldn't have occurred, or wouldn't have occurred with the seriousness that they did, if he had abided by his first offender probationary condition of not having a firearm in his possession. He couldn't have shot an officer because he wouldn't have had to shoot an officer if he had abided by his conditions of probation.
At sentencing, Judge Whitaker explained the reasons for the lengthy prison term. She pointed to the seriousness of Eppinger's actions, the repeated probation violations, and what she described as a clear lack of remorse, noting that Eppinger was even heard laughing about the shooting afterward. The judge also highlighted that Eppinger had been given a chance to change through first offender probation, but chose to return to violence instead.
So the number of the separate incidents, the apparent lack of remorse for any of this, the seriousness of the crimes, and the strength of the state's evidence on these particular charges, and the demonstrated determination to continue a criminal lifestyle all go into the court's sentence determination in this case. So the sentence on count 1 is 20 years to serve 10. On count 27, it is 20 years to serve 10 concurrent. 29 is 10 years concurrent. 31, 5 years concurrent with count 1. The sentence on count 32 is 30 years to serve consecutive to count 1. 33, 20 years to serve concurrent with count 32. 34 is 10 years to serve concurrent with count 32. I'm going to come back to 36 because that is required by statute to be run consecutively to anything else that's being sentenced. That's the only one that's that way, right, Ms. Hilton?
Yes, ma'am.
All right, count 39, the sentence is 20 years to serve 15 concurrent with count 32. 47, the sentence is 10 years consecutive to count 32 but probated. 48, 10 years concurrent with count 47 probated, and then 36 is going to be 5 years consecutive to count 47 and probated. I believe that is, honestly, I'm going to have to do a little bit of math right here. I think that's 75 years.
Eppinger's final sentence covered multiple charges: conspiracy, armed robbery, gang participation, attempted murder of a police officer, and illegal possession of a firearm while on probation. Adding them all up, the judge imposed over 75 years in total, but with sentences running at the same time or back to back. Eppinger is expected to serve roughly 40 to 45 years in prison before any possibility of release. Some counts were ordered to be served consecutively, while others were concurrent or probated. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.